start by taking notices of appearance.
Jeannie Oliver from the Department of Public Service. With me today is Jeannie Elias from the Department of Public Service.
Evan Meenan from the Agency of Natural Resources.
Cindy Hill from the town of New Haven, and with me is Douglas Tolles of the Select Board of the town.
And I'm Leslie Cadwell with Legal Counselors and Advocates, and I'm representing Sun CSA 22, the applicant.
Okay, great. So we're here for an oral argument. I believe, Ms. Cadwell, you asked for oral argument, so we'll start with you.
Great. And I don't have that much to say. We've, I think, fully briefed all of the issues. I want to say good morning and thank you very much. I hope you enjoyed the conference at NECPUC and learned lots. We're asking you to modify the hearing officer's proposal for decision and issue a conditional CPG so that 30 households in New Haven or elsewhere can participate in net metering this summer before there is a rule change next year. The case boils down to really one issue, and that's how many trees and how much vegetation needs to be planted to satisfy the board that there's no undue adverse impact caused by this particular system. When the board ordered this case for hearing, I reached out to the department's counsel to sort of understand if she had any insight as to why this case, as opposed to scores of others that hadn't been scheduled for hearing, that may not have the kind of vegetation or landscaping plans that the hearing officer seemed to feel was either important or not. It's not clear from the P4D, from my perspective, about why we might have a hearing on this. And what we at least surmised was that there was some interest in seeing if the board could encourage the parties to reach mutual agreement on what might be appropriate. Sometimes, I know in my own experience that when you raise the stakes, parties might change their minds and act more reasonably and come together. Unfortunately, in this case, when we made these attempts, they were unsuccessful, and that's really because the town of New Haven's taken a stand really in opposition to the board's plenary jurisdiction over siting. The town has taken a position really not only here but in other cases pending before the board and before the legislature, that towns ought to have the ultimate say in development that goes on in their communities. And if the legislature hadn't given this board authority to site energy projects, we wouldn't have been able to build the grid that we have today, and we wouldn't have been able to accomplish the kinds of goals in cleaning up our local energy resources. As Mr. Tolles, in fact, said to me this morning, a member of the select board here, New Haven wants rooftop solar. They don't want ground mounted. And that's really what this case boils down to.
I understand why what you're arguing now is that you would hope to reach an agreement with New Haven, you weren't able to, and you're trying to explain what some of the motives might be for not reaching an agreement with you. But the fact is the hearing officer wasn't convinced by what you thought. So I think that's what you really need to direct your attention to.
Well, and I guess from our perspective, we don't know what. We only know that there is, he found that there was an insufficient number of trees. Well, I don't know how many trees are needed. We did consult with an expert about that. We incorporated that plan. The applicant actually proposed, before a hearing was ordered, landscaping. After the hearing was ordered, we did reach out to the town to try to settle. There's testimony to that effect in the record. Those offers were rejected. We were asked to move the project. We weren't asked necessarily to plant any specific number of trees. And we've remained open, and that's the testimony of record. If we could get guidance on what would be appropriate, which both the board's rule and the net metering application form lack, we could accomplish that. And so what we're really asking is, tell us what you think would be appropriate here and condition the CPG on complying with that requirement. If the applicant can't or does not want to meet that requirement, it has a choice. But to deny the opportunity based on some vague idea that there's some sufficient amount of trees when there really is no other guidance other than what a battle of experts might say, for example, we really don't know how to address the concern.
So, Ms. Campbell, you kind of summed this up as playing the game of bring me another rock. I'm going to ask Ms. Hill the same question, but from a different angle. So from your angle, why shouldn't you have to bring them another rock?
Well, we would be happy to if they would tell us what they want. But they haven't told us what they wanted. Their witness was here. I inquired of the witness exactly, please tell us what you want. I actually asked for the witness to draw on his plan that was produced during a redirect examination, and I was shut down from that for reasons I still don't fully understand. We just want to know, what do you want, so that we can then accomplish that. Because as you know, aesthetics is really a subjective judgment call. The Queechy test is the best possible way, I guess, to get at, to make objective what really is a subjective inquiry. I happen to think solar panels are beautiful. I testified to that effect during the net metering rule public hearings. Somebody else, like Mr. Tolles, doesn't. He likes to see them on roofs. These are personal opinions.
But the issue was screening, and I think that the point was that the screening that you proposed was not effective. They want the project to be screened more effectively so you can't see it from certain vantage points. That seems like enough guidance to me without having to nail down plant tree, picking for you which trees and where to plant them. That seems a little excessive. So
Well,
I think you have guidance, it seems to me, and
so there are no findings in the proposal for decision on what views need to be screened. I beg to differ with you. There are none. So I don't know what views need to be screened. I suspect there are probably views from South Street, but how much? There are no findings. There are no findings on how much screening really is required. Is it that they can't see it? The town's expert witness conceded that you don't actually have to completely hide a project. His actually recommendation was to move it into a wetland, which actually violated a very clear provision in the town's town plan, or put it on property that the applicant doesn't own or control. Those are not reasonable mitigation measures, either of them. I'm done.
Okay.
And so I just thank you and hope you'll give us the opportunity to either make a subsequent filing or give us a requirement that we can actually meet, instead of just denying a CPG because for some reason the hearing officer perceived there were an insufficient number of trees without giving us any idea of where those trees should be planted, how much they should screen, and for what purpose.
However, I would note that in addition, you mentioned the suggestion that was made was to move the project into an inappropriate spot, but I understand that that New Haven had also did make some suggestions regarding the plantings, to wit, includes a mix of very high deciduous, evergreen, and herbaceous species, and staggered and irregular groupings reflective of the surrounding landscape.
So with respect to evergreens, Mr. Moore's testimony was clear. He would consider them. The problem is that evergreens grow to a height that are unsustainable for solar, and they would require regular maintenance. If what the expert that we relied on, Jean Vissering, whose landscape plan the hearing officer completely discounted simply because we didn't produce her as a witness, not knowing that he wanted her to testify. We didn't feel that we needed to. Often people file plans and reports that they use as part of their regular course of business, which SunCommon, which is a sponsor of this project, does regularly. That was the reason they had made the recommendation before the hearing to include certain species. She recommended something different. If what the board thinks is appropriate is to stagger them, certainly we could file a landscape plan that shows the plants staggered. With evergreens, again, the problem is the site is constrained. It would be difficult to locate them, as I understand it, within the footprint of the array without actually affecting the essential purpose of the project, which is to produce electricity from the sun.
Did you consider subpoenaing Ms. Vizuri?
We didn't feel we needed to. It was, had we been notified that it was essential to have her here as a witness, absolutely, we would have brought her. In fact, Ms. Oliver could have brought her as well. The department was a party. We just didn't, what we understood from the board's hearing order, that the only issue was to look and gather more information on whether there were additional, I'll characterize it, additional generally available mitigating measures to improve the project's harmony with its surroundings. That's a judgment call. And there really is, I think there's sufficient evidence in the record for the board to say, we would like, depending on what testimony you want to believe or give more credit to come up with some guidance and have us provide a compliance filing. That's a regular practice before the board. This proposal for decision really came as a surprise because normally the board does modify the landscape plans that applicants file in their final order based on the evidence. The Cold River project is a really good example. A much larger solar project in Rutland. The applicant or the petitioner presented a landscape plan. Other parties weighed in. The board ultimately said, well, we are going to accept your plan, but add some or modify it a little bit to address the additional concerns. The evidence of the record in this case, you could do the very same thing.
Thank you, good morning. And thank you for this opportunity. This board, I'd like to just, I think we have briefed the case law and some of the legal points, and I'd like to sort of address the gestalt of the thing if I can and respond to some of the comments Ms. Cadwell just made. This board's routinely found that ground-mounted solar arrays in a rural context create an adverse aesthetic effect, and there's a long list of cases that I've cited there, and that's been a fairly standard finding just because they're out of context for the environment. And then in terms of the second half of the Pucci test, you primarily focused on this question of whether the applicant has taken commonly available measures that a reasonable person would take. In terms of guidance in that point, many of the cases we cited in our briefs here have all noted the fact that there is clear guidance as to what has been considered in that. One is the siting. Many of the cases you cite where landscaping was not necessary or where a post-CPG landscaping plan can be put in place were sites where there was natural vegetation or natural terrain screening that already partially screened the project, and the question was just sort of enhancing that or polishing it up or perhaps planting to screen from a different angle. And you look at this particular case and we say, why are we here talking about aesthetics in this particular case? This is in a wide open flat field front yard next to a road with no roll of terrain and not a single twig standing to hide it. It's just plain right there. So therefore the question of what you're going to do to mitigate it becomes the primary focus. In terms of moving the project, I think the applicant has mischaracterized both in its briefings and here today this question of moving it into a wetland. That was never requested by the town. It was always requested that the project be moved eastward behind what we're calling the hedgerow, which is an identified wetland area. And if you look at the applicant's application, their parcel boundary map clearly indicates that that wetland is not the eastern boundary of the property as the applicant has represented in their arguments and in their briefings, but it's actually pretty much sort of roughly in the middle of the property, and all of this area behind it, which is where we'd ask that it be moved, belongs to this landowner, and it appears from this view to be even larger than the area where it's being located, and it would be behind the house and behind the hedgerow on a south-facing slope that is under control of the landowner and that is not in, as you can see, the identified wetland area. So that's a mischaracterization in terms of we've never asked that it be moved into a wetland. Would it be on the other side of the wetland? Sure. So would that involve some kind of a crossing, especially at least for the wires? Sure. But that has been addressed in numerous solar arrays, as you know, just getting, obviously they'd have to get the wetlands permits, comply with those laws in order to put that through, but the town never asked that it be placed in that wetland, nor is that wetland the eastern boundary of the property.
May I just object that she's actually providing facts that she could have provided with an with a witness. This is actually new evidence.
No, it's not evidence, it's oral argument.
Okay,
We
well,
can't
I'm just-
rely on it.
Fair enough, well, I'm just saying that all of this that she's raising, this was raised in pre-filed testimony, the fact about where the project was to be moved and that kind of thing. If she wanted to, let me just know for the record that there is no evidence to support anything that she's saying right now about the request or the location, the boundary lines or anything. It's not in the record.
The property boundary map is in the applicant's application, and on page 12 of Mr. Lawrence's aesthetics report, it says the most logical mitigating step is to move the project to limit its public visibility further from the road behind the existing vegetation. So I'm correcting the misconception that it was asked to be placed in that wetland. It's a misconception made in the briefings, including the comments on the proposed decision. Leaving that aside, turning to the landscaping mitigation, the applicant here not only presented a landscaping proposal which was substantively inadequate, but the diagrams were out of scale and misleading in terms of what that was. There was significant testimony, and we've addressed it in the briefing as well. Mr. Lawrence submitted diagrams showing the scaling of that. There was a lot of conversation in the testimony about the scaling of it, how it was misrepresented in the diagrams in terms of the adequacy of that screening. And there wasn't someone to testify that the screening proposed by the applicant in fact was sufficient to mitigate the aesthetic harm.
So Ms. Hill,
Yeah.
Going to be, you heard me ask Ms. Campbell.
Another
I'm
rock.
going to ask you from the other side, give me another rock. Why can't you be held to at least giving them a clue what rock you want?
Again, in the, there were discussions back and forth, and there were attempts to resolve. I know that there's not additional evidence in terms of what the town's response was to those, but suffice it to say that resolution did not occur. There is in the record evidence that the planning commission minutes that were submitted looking for additional trees to be planted from what was proposed. Again, at Mr. Lawrence's testimony, on page 12, he notes none of the 18 plants proposed are evergreen. All of them mature at relatively small sizes. They're not in sufficient quantities to shield 185 feet, and the plan doesn't address visibility from either side, that is from the side, the north and the south of the project. So therefore, it's insufficient to improve the harmony of the project. So again, that's on page 12 of the Mr. Lawrence's aesthetic report, and I would say that was fairly specific in terms of guidance of what the shortcomings were in this plan. Again, we've briefed quite a number of cases where this board has made specific recommendations as to numbers of trees or dollar amounts to be spent or the types of considerations to go into those views, and we cited both in our post-hearing brief and in the comments a number, not by any means an exhaustive list, but a number where this board has very clearly laid out what's reasonable in this situation, and there's a long list that certainly gives guidance as to what's reasonable. Again, in most of those situations, there already was some natural vegetation or terrain that helped, but they certainly do provide some assistance here.
Ms. Hill, if at this point you were asked, what does the town want? You don't have to tell me what you want, but if you were asked, could you then now, have you come far enough along that you would be able to describe what you want?
I think it's been described through the testimony, and Mr. Lawrence has, talked about, Mr. Lawrence's testimony and what has been described are the kinds of techniques we would look to in terms of naturalized hedgerows, mix of evergreens, sufficient quantities. Mr. Lawrence testified about having views from the corners, which can really help to break up the the view of something. But to actually produce that plan, of course, requires ground level photos and plans, coming up with photo simulations, and it's a, so we did not, as the town, undertake that, costly endeavor to do that. So I think we have made a long list of the suggestions of techniques that would need to be applied, but someone would need to.
But not a defined rock.
Right, right. In terms of this question of issuing a CPG now that says, and submit a landscaping plan later, I would submit to the board that this case is highly inappropriate for that. That's what this hearing was about. That's what the opportunity was to do. And I would note that if you were to issue an order with a post-CBG landscaping plan, that would require this board to maintain jurisdiction. It would require future back and forth amongst all of the parties. And I'll note that just 2 weeks ago, in Sun CSA 42, NM 5904, this board denied a request for reconsideration where one of SunCommon's projects, in the year of the time frame of the CPG, was unable to come to agreements regarding landscaping, and the CPG expired, and then they requested an extension, and then you were back on a reconsideration for extension. So in this case, I think in terms of the interest of justice, the definitiveness of the case, that after a full hearing on aesthetic mitigation, to then order them to come up with aesthetic mitigation, we've already done that. This was the opportunity to do that and be through with it. I'll also note, just in terms of larger picture, right now, with the net metering cap in existence with GMP, that if this project is denied and comes off that queue, another project will go in. So in terms of the public interest, in terms of households to be served, in terms of advancing energy goals and plans, this isn't, there's not an individualized harm of denying this particular project. This project is, given the siting issues with this project, it's on single phase line as well, on a, rural road, that denying this one means another one that most likely may well have much better siting situations or aesthetic mitigation situations, is going to go in. So there's no, in terms of the general public policy, there's no net loss to denying this particular project, and there might well theoretically be a net gain. So instead, if you ordered a CPG that required landscaping plans, we're going to have, this conversation is just going to continue. The board's going to have to maintain jurisdiction. The project won't get built while we're working on that. And as just happened with this other one, it may well come to the end of the day and not be done. If you issued a denial, another project on the list will come in instead. I just had one point to raise regarding the hearing officer's decision. It references the town zoning bylaws, and I just wanted to note that if you look at page 8 of the town's post-hearing brief, you'll see the town made its argument based primarily on the town plan, that it is in a rural planning area under the town plan, and we cited that within the rural planning area, according to the town plan, development should be severely limited to conserve these resources and so on. The hearing officer is correct, however, that at the very end of that paragraph, I did cite the zoning bylaw, and we did not attach that page, although we're well aware that the board has been clear in not considering those zoning standards specifically, but the crux of the argument was under the town plan, that it was in the rural planning area, and I think the hearing officer focused on it being a zoning standard when that wasn't our argument. It was the town plan. So that's in the great scheme of the decision, it was a small point, but I just wanted to correct it as I thought it was a little bit off tangent. Happy to answer any further questions.
Yeah, thank you. Just 1 second. Do the department or A&R have any points you want to make?
First, I'd like to give a little bit of background about our involvement in this case, because we have some questions about it. In this case, given that the only issue at hand was really whether reasonable mitigation measures had been taken, we determined that the best use of our resources was to try and facilitate negotiations between the parties. In our experience, when parties come together in a collaborative way,
Right.
it usually results in better projects and outcomes that both parties, or more than just the parties that are litigating, are happy with. And we think that it probably enhances the community's acceptance of renewable energy projects. So we really try and encourage that collaborative process on mitigation. So we asked Jean Visserin to provide us with some recommendations that we could put to the two parties for them to use that as a possible alternative or a starting point for their discussions. So that's the background on where Jean Visserin's advice came from.
So you asked her to do that, and did she do that?
She did do that, and we forwarded that recommendation to both parties.
Okay.
I guess in this case it's a little bit unusual. It's different to other cases that I've worked on where reasonable mitigation measures have been the sole issue, in that in other cases I've worked on, the parties have either started that collaborative process and come up with specific alternatives which have either been accepted by both parties, or if they weren't, then there was something quite concrete for them to litigate about. In this case, I think the hearing officer had quite a difficult decision to make making his recommendations, because the evidence of record was not that specific, and in that way it differed from the usual case. That said, the department agrees with the hearing officer's analysis of the relevant burdens in this case. There is a burden of production on the applicant. If that is met, then a burden of production on the challenger, and then ultimately the applicant bears the burden of persuasion. We think this case is really about the weight to be given to the evidence that was produced. And so to touch on the bring me a rock analogy, I think in cases where the evidence includes not just, where it includes an expert as the town put on, and a statement that what the applicant has proposed is not sufficient, if that evidence then goes on to produce an alternative and argue that that alternative is reasonable and feasible, then we think that that evidence is very weighty, and then it's sort of a sliding scale. The fact that they did not produce a concrete alternative really just goes to the weight of the evidence.
They being the applicant?
Sorry,
Yeah.
the town.
The town.
However, we do think that the town's expert did suggest a fairly concrete alternative in this case. If you look at the transcript, there's evidence that where Mr. Lawrence states that the species of trees that the applicant proposed were appropriate for the area, and when he was pressed on an appropriate number of the proposed species, he said about twice as many. And so we believe it's possible that a CPG could be granted with the condition that the species chosen by the applicant, twice as many, be planted. We also recognize that, in many cases, there's more than one alternative that might be reasonable or desirable, and we think that might be the case here, because Mr. Lawrence also talks about a different mix of species. But we don't have the number in the record if there were a different mix of species. So I haven't been able to sort of grasp onto that as a specific recommendation that I might make for a CPG condition, but we do recognize that there are different alternatives that may be reasonable.
Thank you. And the alternatives that Ms. Visserin proposed, do you think those were reasonable?
We stand by Ms. Visserin's recommendation, but we also recognize that it was not introduced as testimony.
Right.
And Mr. Lawrence's evidence said that it was going in the right direction, but he still believed that greater number of trees were required.
Okay.
So to the extent that that is what's available on the record,
study back to record.
Okay, thank you.
Just have a couple, just a couple, responses to, Ms. Hill. Mr. Lawrence's pre-file testimony, that she referred to in criticizing the applicant's landscaping plan was not based on the landscaping plan that was pre-filed. It was based on the landscaping plan that was filed, in response to comments from the town, of New Haven. We did not get a response from Mr. Lawrence, or a proposal for alternative landscaping until he testified here. And it was for that reason that, we tried to probe what it was that he thought, would be better in this case. Second, the hearing order simply said that the board needed more information on whether the applicant had taken generally available mitigating measures. It did not state whether the applicant's landscaping plan was sufficient. The applicant took additional measures at Ms. Vissering's suggestion, and in fact improved on Ms. Vissering's suggestion, which included, Ms. Vissering had suggested to paint some of the equipment a darker color so it would blend in better with the array and the area. Rather than do that, what the applicant did is it moved that equipment away from the road, put it behind the panels, in addition to adding and accepting as reasonable the landscaping plan that she had prepared to hopefully bring the parties together. As Mr. Moore testified, in response to the applicant's and the department's efforts to try to engage, the response was move the project or pay more in taxes. It wasn't what Mr. Lawrence ended up testifying and hearing, well, you could do this, you could do that. You might want to start with looking at what's in the area. And basically, we didn't get any of that until the hearing. And finally, I think Ms. Hill does raise a really important point about how costly an endeavor it is to hire a professional landscaper to come up with professional stamped landscape drawings for a project that the board, in its own words, in response to comments on the current application, is that these projects have, they're relatively small in size, and the application form doesn't require the applicant to supply detailed information regarding impacts. And in light of those comments, and the application form itself that doesn't instruct applicants to hire somebody like Mr. Lawrence to prepare those costly plans, it would have, it would seem that if the board were to continue to approve the proposal for decision and deny a CPG, what the outcome not only would be, I think, as I noted in our comments, a violation of the applicant's due process rights for not being noticed that these things are required. But even more importantly, you will encourage parties not to settle. You will get more requests for hearing, and you're going to have battle of experts, when really what at least I think the board's simplified process is designed to do is to allow people to use their judgment about what resources they should invest in order to satisfy the customer demand for these projects. So I would encourage the board to follow the practice that it has for decades, and that is to issue a conditional CPG that addresses the merits. It doesn't treat a hearing for a 150 kilowatt net metering system as a civil dispute where the board is calling balls and strikes and not actually getting to the merits and the public good, which is, I think, what the P4D really reflects. So thank you very much.
So, Ms. Hill referenced societal benefits, and in the applicant's comments on the P4D on page 23, it's twice mentioned that the proposed community solar array will save modestly Vermonters' electric bills while helping the state meet its clean energy goals. And just a general question about that to help me understand, using this as a case. Given that the application form says that the RECs will be retained by that applicant, those RECs will not be available to meet the state's renewable energy standards. So which clean energy goals are being referred to as being met?
I would say that the applicant retains the RECs may not mean that the utility gets to satisfy a new statute, but the solar array still produces electricity from the sun. It doesn't use fossil fuels, and in that way, the project does meet goals, even if they're not counted towards the utility's renewable energy standards.
So we meant goals generally, not specific requirements.
That's correct.
Thank you very much.
Thank you very much.